Okay, if you're waking up to my podcast this morning, good morning, everybody. Following on from my podcast yesterday, which was going quite well on X, I had to jump straight in again in between. I've got a very busy day, but now this investigation is going on with Rupert Lowe, who's an MP. I want to jump on here with my podcast on MPs and what I experienced in my fight to try and protect my child. So I'm going to stick to script because I don't want to say anything that I shouldn't. Because over the years, it's got me into a lot of trouble. But I'm going to explain it slowly. Now I've got your attention, I'm going to do 2 podcasts in one. Because one actually follows on from the other, because people are going to think, that can't happen. Why does that happen? It makes no sense. Yeah, well, there's a lot of things that we aren't being told. So, right, here we go. The first part of this podcast is called When MPs Cannot Act. Why family courts are shielded from democratic challenge. Mother's Nature, deep dive investigation. This is a short intro clip on top of my short intro clip. This episode asks a question every mother eventually asks. If so many mothers go to their MPs, why doesn't anything change? The answer is not that MPs don't listen. It's that the system punishes those who challenge it. In this episode, I explain why family courts are shielded from democratic challenge, what happens when an MP does speak out, and why mothers are always forced to stand alone. This is not about blame. It's about understanding power and how silence is maintained. When our MPs cannot act, by design, how delay, secrecy and power silenced a mother. Mother's Nature, Consolidated MP podcast. I need to begin by saying that I am deeply troubled by what my investigation has covered. I spent years trying to change laws, persuade institutions, and demand action from the police. What I understand now is this: the system is not failing. It is working as designed. I always knew that. What I did not understand until now was how. Today I do. This podcast follows events in order so they can be understood clearly. Private family law, private family court enforcement, parliamentary intervention, police delay, the use of the word historical. I know that'll get all you mothers listening. I'm sure you've heard it. High court escalation and loss of liberty. Private family court enforcement. During private family court proceedings, I breached a contact order multiple times to protect my daughter. I remember how many times I breached that order. It was 15. The response was a 12-week suspended sentence. In practical terms, this meant comply and hand my child over or go straight to prison. This decision was made in private without public scrutiny. Speaking in Parliament and constitutional protection. I later spoke at a parliamentary meeting. Speech in Parliament is protected by absolute parliamentary privilege. I was not in contempt for speaking there. I was assured at 34 weeks pregnant that I was safe. John Hemming MP named me in Parliament because he recognised that attempting to punish or silence a citizen for protected parliamentary speech raises a constitutional issue. Parliamentary privilege exists so Parliament can hear evidence of injustice. When family court secrecy collides with parliamentary oversight, Parliament must prevail. And I just want to jump in here. What other MPs do when one MP uses parliamentary privilege. So another MP, John Mann, publicly criticised, it was reported in the press, publicly criticised John Hemming for speaking out. I was sitting in front of him at the time. He was my MP. I listened as he chose not to support a colleague who was defending a constituent against clear state overreach. I was deeply disappointed. John Mann knew me. He knew my case. Yet when another MP that I was not a constituent of stuck up for me, my own MP at the time criticised him publicly. Because what I saw in that moment was not politics. It was fear. Fear of crossing a line. Fear of challenging a system that does not tolerate scrutiny. Fear of being associated with a woman who would not be silent. Letters from Rosie Winterton MP and police delay. For a period of time, I was under Rosie Winterton, under her constituency. Rosie Winterton MP wrote formally to the police asking questions about child sexual abuse concerns in my case. The standard response time for such correspondence is 4 weeks per letter. Replies did not arrive early. They arrived late, partial or deflective, pushing the matter further down the road. Delay is not neutral. Every week after a disclosure reduces the chance of usable evidence. Months passed before my daughter was interviewed. By then, evidence was gone. This outcome was predictable and known. What historical really means, women are told when they bring up child sexual abuse, it's historical. And then I'm going to explain. Mothers are often told allegations are historical. This does not mean untrue, resolved or safe. It marks the point where accountability stops and management begins. The label can be applied even when disclosures are recent. Once time has been allowed to pass, the same delay is then used to justify inaction. Abuse becomes historical because time was allowed to do the work. The double standard. Scrutiny for one parent, protection for the other. As you follow me through these podcasts, I want you to see something clearly. I did not stop trying to protect my child after she was removed from my care. I went to members of Parliament. I spoke in Parliament. I attended protests and rallies. I spoke at protests and rallies. I communicated with journalists almost daily. I did radio interviews, podcasts, and I even appeared on French television. I can honestly say not one single day went past without me doing something to try to protect my daughter. My case is often described as high profile, but it did not begin that way. I made it so because I refused to be silenced. I was arrested several times, charged several times, and in prison more than once. And I still would not be silent. I refused to carry the shame the system placed on me. The system tried to place on me, because that shame does not belong to me. It belongs to the system. And this channel exists to demonstrate that. In stark contrast, the other parent involved in my case was subject to a social investigation that was criminal in nature. Yet it did not result in prosecution, and it did not result in public accountability. Instead, it resulted in protection from scrutiny and protection from public view. This is a pattern mothers recognise. The protective parent is treated as the problem to be managed, while the alleged risk is contained quietly. I really do hope that Rupert Lowe watches some of my podcasts, because it really will become clear to him. High Court give cause while pregnant. In 2011, while 34 weeks pregnant, I was summoned to the High Court to give cause why I should not be imprisoned. This presumes imprisonment and requires the individual to argue against it without an open criminal trial. This is what caused John Hemming to step in. Recall after release 2012. After serving a custodial sentence, later reduced on appeal, I was recalled during the licence period. This recall did not involve appearing before a judge. It was administrative. There were reasons around this. Obviously, I was causing havoc again with the authorities. Those pesky mothers. Closing statement. The system has been designed the way it operates. The pathways, incentives and outcomes are not accidental. When accountability is avoided, delay becomes a tool, secrecy becomes protection, and power escalates. I am speaking now not out of anger, but because understanding carries responsibility. So I'm going to hop straight into the financial train. How child removal generates billions, not millions, billions. And what happened to my daughter? This is another Mother's Nature deep dive investigation. This follow-on explains how money flows once a child is removed from their mother and why this matters. It is not an allegation of conspiracy. It is an explanation of incentives, structures, and outcomes that repeat over time. But this is not abstract to me. I lived it. My daughter was born in 2003. She was removed from my care in January 2010. At first, she was placed under an interim care order with her paternal grandmother. That's where the money starts to flow. Later that same year, in November 2010, a full care order was made and my daughter was placed with her father. From that point on, the state retained legal authority over my child, even though she lived with a parent. The care order remained in place year after year. What I did not know at the time, and was not told, was that serious safeguarding concerns later arose not long after. Between 2015 and 16, the local authority became aware of a local authority designated officer investigation, they're called LADOs, concerning my daughter's father. The investigation related to inappropriate communications of a sexual nature with a child in his role as an athletics coach. As a result of that investigation, he was suspended and ultimately lost his licence to coach children under 18. UK Athletics was asked not to publish the ban. That's not in the public interest, because the public don't know that he's a risk, so the public can't protect their children from him. The ban was kept out of the public domain. And crucially, I was not told. Later, in 2022, Matt Lawton reported on a total lifetime ban from coaching children and adults, although he still promotes himself as an athletics coach on a public website today. The report, Matt Lawton, he's the sports editor for The Times, and he was the only journalist that reported, that got the article in the press. There were others that that tried but were blocked. So a risk assessment was carried out. Despite the findings, my daughter remained in his care under a full care order. By 2016, the situation had become what professionals privately described as a hot potato. The local authority wished to discharge the care order, but the father would not cooperate with the assessments or reports required for discharge. The reason later became clear. If the care order were discharged, the application would have been put into court and I would have been a party. So I would gain access to information that had been kept from me. As a party, there's bundles and you're given bundles. Information about the investigation, the ban and the safeguarding concerns. What they actually tried to do is minimise it. There was just the word Lado. But I think the fear was, if I knew the ins and outs of the Lado investigation, what could I do with this information, knowing me as they already knew me, a huge risk of speaking out, going to Parliament, going to the press, protests in Parliament Square, speaking, being on YouTube. I mean, where I haven't been was not worth going. For 2 years, applications were delayed because he did not comply. During that time, I was still excluded. In 2018, an application to discharge the care order finally went before the court. I attended every hearing, and it was only then that I learned the full picture. My daughter... My daughter was struggling. She had been seriously underweight. She suffered anxiety and panic attacks. She was not coping at school. I also discovered that she had been hospitalised with a life-threatening illness. I had not been informed. These were facts recorded in professional records, not my opinion. All of this occurred while my child was supposedly protected by a care order. This is why the funding structure matters. The care order generated ongoing professional involvement, oversight, reviews and expenditure. But it did not generate transparency for the mother. It did not generate safety for the child. I think I've already explained. When a care order is in place, spending continues regardless of outcomes, and the money comes from central government into the local authority coffers. The order itself sustains the system. Leaving a child safely with a protective mother generates little revenue. Removing a child or retaining control through long-term orders activates the financial drain. This is not child protection, it is system preservation. And when a system preserves itself at the expense of children and mothers, it must be examined honestly and publicly. So there's my 2 podcasts in one. I would invite Rupert Lowe to contact me, and if there's any part of this system that he really just can't get into a normal brain, I can help there with what's black is actually white, what's truth is actually lie, and they all in the system, there's no blame, are all doing what they are paid to do. So I'm going to end it here. I'm going to get this on on my channel as soon as possible, and I wish you all a very good day. Bye.